Good afternoon, everyone, and thank you for joining us for another edition of our webinar series, Inside Immigration. Today, we're joined by panelists at Green & Spiegel, Peter Salerno and Alannah Glintz. Please feel free to ask any questions via the pop-up text bar on the right side of your screen, and we'll do your best to address your questions at the end of the webinar. If the panelists do not get to your questions, feel free to contact them to book a consultation. The information provided is on screen now. With that being said, I'm going to hand things over to our panelists.
Good afternoon, everyone. Thank you so much for joining us. The purpose of this webinar is really to provide some recent updates that we've seen, as well as trends that we're currently seeing with respect to really all areas of immigration law that we practice here at the firm. So we have posted the agenda for the topics that we're looking to go through, but as Stephen mentioned, if you do have any questions, please insert them into the application and we can try to get to them best we can. Otherwise, we do encourage you to book a consultation and we're happy to discuss anything further with you. So as you can see in the agenda, we're going to be talking about permanent residence. So we're going to talk about express entry, some updates that we're seeing. We're going to talk about the recent update with respect to the parental and grandparent sponsorship. We're going to be talking about students, also the amendments to the regulations, the immigration and refugee protection regulations, in particular, the implications that this will have on employers. So we have gone through this on a previous webinar, but we really do want to drive home some of the updates with employers. And we'll also, talk about, some best practices in there as well. We also will talk about processing delays that we're seeing and timelines, just generally, as well as updates with respect to Ukrainian nationals. And at the end, we will end with the questions. I'll leave it over to you, Peter.
Okay, hi everybody. Nice to be with you all today. My name is Peter. I'm one of the senior associates here at Green & Spiegel. The first topic that we wanted to cover today was really express entry. It's a very important program the government has. It's an electronic application system for foreign nationals wanting to apply for permanent residence. Foreign nationals can either be inside Canada or outside of Canada to use express entry or apply under express entry. And basically, the way it works is candidates submit their profiles in the express entry pool, and those with a high enough comprehensive rating system or CRS score are given invitations to apply for permanent residence. Now, the CRS score is determined based on primarily age, education, work experience, and language abilities. And it's important to note that the government of Canada stopped issuing invitations to apply for permanent residence and basically suspended the express entry system at the federal stage for many, many months until recently in the summer. And most recently, the score needed to receive an invitation to apply for permanent residence. There was a draw in October, I believe it was October 12, and you would only receive an invitation to apply for permanent residence if you had a score of at least 500 points. 4,250 invitations were issued. Prior to that, there was an earlier draw on September 28th. A few hundred less invitations were issued, and candidates needed a score of at least 504 points. So there seems to be a trend of IRCC lowering the minimum necessary CRS score to receive an invitation to apply. Before the pandemic, it was significantly lower. So there's widespread consensus and belief that the government will continue to lower the score. It is, however, unclear how much it will be lowered by the end of this year and how quickly that will occur. So that's really where we stand with express entry right now. It does seem like immigration is conducting draws somewhat more regularly, like it used to be before the pandemic. So that in and of itself, that predictability, that consistency is, I'm sure, a good thing and welcome for a lot of our clients who are eagerly waiting for that invitation to apply. The next area we wanted to cover is the parent and grandparent sponsorship announcement the government made on October 11. This is a really, really popular program, understandably for Canadians who want to bring in their loved ones, their parents, their grandparents into Canada. IRCC confirmed that 15,000 applications would be accepted. Now, the invitations to apply under this program are only going to be provided to certain people. Only Canadians who submitted an expression of interest to use the program between October 2020 and November 2020 will be considered by IRCC. So that's approximately a group of 155,000 people who in 2020 informed IRCC that they would like to sponsor a parent or grandparent. So as of October 12 to October 20, IRCC randomly selected people within that group and informed them by email that they would be selected and given a spot under the new program this year. So it's only for people who had already expressed interest to use the program, unfortunately, just because they hadn't been selected before. So IRCC is therefore giving them first access to the program this year. Now, obviously, there's lots of people who would like to sponsor a parent or a grandparent who aren't in that pool. And to those people, we would recommend contacting us. We could potentially look into applying for a super visa on behalf of the parent or grandparent. There are new allowances and changes to the super visa program that allow for parents and grandparents to stay for up to 5 years consecutively. So that is a good option for a lot of people who are not given the opportunity to use the actual sponsorship program. But we would recommend, it's a case-by-case basis based on the Canadian sponsors' income is a major component of the super visa application. As well, you would need to provide proof of medical insurance coverage for your parent or grandparent who you're wanting to sponsor. So really, those are the two main updates as far as the parents and grandparent sponsorship program are concerned. And with that, I'll hand it over to Alannah to cover the new policies for students.
Thanks, Peter. So with respect to students, we have one main update and then some other temporary policies that remain ongoing. So some great options for individuals that are here on study permits right now or that have applied for study permits. So first, most recently on October 7th, there was an announcement made that students are now eligible to work more than 20 hours per week while on their study permits. So traditionally, assuming they meet the eligibility criteria, students are eligible to work a maximum of 20 hours per week. However, this temporary policy allows to work more than 20 hours. So in particular, it is from November 15th, 2020 to December 31st, 2023 that students are able to work more than 20 hours per week. So theoretically, a student could work full-time hours. This was not permissible previously, but is a great option for students, and it is meant per IRCC to address some of the labor shortages that we're seeing throughout Canada right now. So there are some criteria that needs to be met in order to work more than 20 hours. So the individual must hold a study permit and must be studying at a designated learning institution on a full-time basis or on a part-time basis during their final academic session, or they have to have been approved for a study permit but haven't yet traveled to Canada. They have to have had that approval in hand. There's some other criteria that also needs to be met. So they must ensure that IRCC received their application for a study permit on or before October 7th, 2022, which is when this new policy was announced. They must have off-campus work authorization for the study permit, and they must be either in Canada or coming to Canada by December 31st, 2023. So that's the criteria. So employers should also be aware of this, because this would sometimes mean that they don't need to get an additional work permit for their individual that's on a study permit. Maybe this individual can actually work full-time hours based on this policy. Just be mindful of the dates for that particular policy, and if it is extended, we will make a post on our website as we hear. And that leads me to another temporary policy for students that is still ongoing, but we did want to flag. So the postgraduate work permit temporary policy, which allows postgraduate work permit holders to extend their postgraduate work permit for up to 18 months, is still in effect. So again, another great option for individuals who have held or hold postgraduate work permits. The caveat to this is that work permit must have expired or be expiring between September 20th, 2021 and December 31st, 2022. So we're coming up kind of on the end of that particular temporary policy, but it's unknown at this point whether it will be extended. So again, we would send out a notice on our website and social media if that does occur. But as of right now, this is looking like it's going to end December 31st, 2022. So you would want to get your application in before that time. So that brings me to the end of the students. So kind of shifting gears to the amendments that were made to the Immigration and Refugee Protection Regulations and the impacts that this would have on employer compliance in particular. So we did speak about this briefly on our previous webinar, and there are some articles posted on our website, so we would encourage you to take a look at that. But there are a few pieces that we wanted to flag in particular for employers, but also for workers as well, just so you're aware of these changes and how it would impact you and your current practices. So in summary, the main kind of take-home points that we want to flag for you are first, that on or before a foreign worker's first day of work, employers must provide them with the most recent information about their rights in their chosen official language. So there are pamphlets posted on Immigration's website. There's a pamphlet for LMIA exempt workers and a pamphlet for LMIA required workers. So it's easy enough to kind of print it off or download it and provide it to your foreign workers as part of either your onboarding process or kind of ongoing processes with foreign workers. As a best practice, we would ideally recommend that you have that foreign worker sign some type of acknowledgement indicating that they've reviewed and confirmed receipt of that information pamphlet about their rights, and then keep that on record, and that would be beneficial in any type of employer compliance situation. So let's say, for example, that individual's work permit is audited, you would have proof that you complied with these amendments to the Immigration and Refugee Protection Regulations. And we actually are already seeing these particular requirements showing up in our audits. As recent as this week, we had one. So it is important that you amend your processes to actually address some of these changes. Another change that we want to flag is if it's not already your practice, you're not already doing so, foreign workers must be provided with a copy of their signed employment contract or agreement that outlines their occupation, their wages, their working conditions, and this should be given to them on their first day of work. So again, this is something that could come up in a compliance situation where you're asked to provide some type of proof that the foreign worker was provided with their contract. So it's important that you're keeping records of that as well. You want it to be signed by both parties, etc. Another update is the prohibition on charging or recovering fees from foreign workers. So for LMIA required workers, it is now prohibited for the employer to recover or charge any type of fees associated with the LMIA application. And this not only includes the LMIA application fee of $1,000, but also any legal fees related to that LMIA. So if you did retain counsel or another representative to assist with the LMIA process, you would not be able to recover those fees from the foreign worker. Also for LMIA exempt, the $230 employer compliance fee cannot be recovered from the foreign worker either. That would be the responsibility of the employer also. And then with respect to any recruitment, employers must ensure that any recruiters that are used do not charge or recover any fees from the foreign worker in relation to the recruitment. So, you know, it's important to really take a look at the fees associated with the application and ensure that the correct party is paying for the different fees. You know, if, for example, you have an arrangement with the employee, I mean, generally speaking, we usually see employers cover all fees associated, but I would recommend taking a look at these amendments to confirm exactly which fees are the responsibility of the employer. One more update with respect to the amendments. Employers must make reasonable efforts to provide access to healthcare services when a worker is ill or if they become injured at the workplace. So a little bit general, but there do need to be, you would need to be able to demonstrate that reasonable efforts were made to provide that access. In particular for LMIA-based foreign workers, individuals on LMIA-based work permits, the employer is also required to obtain and pay for private health insurance for that time period where the foreign worker arrives but is not yet eligible for provincial or territorial health insurance. So that's another requirement that you would want to ensure is being met, and probably, you know, something that you would need to kind of have in place prior to the foreign worker's arrival if it's someone who's coming from outside of Canada. That pretty much covers the amendments. Like I said, we do have some blog posts up about this that, you know, provide an overview in a nutshell that would be helpful. If you do have any questions for us, or if you would like to discuss your company's practices, we're happy to have a consultation to discuss that further. Shifting gears a little bit to processing times generally, we are still seeing processing delays kind of across the board. Government processing times that are posted online do appear to be decreasing, which is something that we like to see. However, there is still a caveat or a note on the processing times on that portion of the website that indicates that in particular for work permits, different priority occupations are being prioritized. So we can still expect, you know, delays that are subject to change without notice, and certain applications will be prioritized over others kind of on an ongoing basis. I also wanted to flag that access to information requests are still very lengthy. We had traditionally seen these processing in about 30 days. It's not unusual now to see, you know, up to 6 months processing for some of these requests, unfortunately. So something to be aware of if you are intending to file an access to information request. Peter, any other insight on processing times on your end?
Yeah, just to jump in, I'm also seeing those same processing times for access to information results. It's excessively long, unfortunately, at this time. And I am also seeing significant processing delays for consular applications. There's certainly more applications being processed within what we would consider more reasonable or normal processing times. There are certainly applications that are falling outside of those normal processing times. Just as an example, I had one application that had been was a passport request. The application was decided finally, but it took 2 years, and that just came in a few minutes ago prior to this discussion. So there are certainly applications that are languishing. I would recommend, if your application has been delayed for an excessive period of time beyond the standard processing times listed on IRCC's website, for you to contact us. We're happy to review the case and the details of it. There could be options that we would bring up to you and explain some steps that we may be able to take to expedite a decision. But we would need to look at the case and the details specific to it before we could advise on that. Anything else on your end, Alannah, for processing delays, or?
I think that covers processing times for me.
Okay.
Yeah.
All right. All right. So then the last thing I wanted to cover briefly before going into some questions was just these temporary measures that the government of Canada has implemented for Ukrainian nationals. So significant numbers have been processed under the Canada-Ukraine authorization for emergency travel. Since January 2020 of this year, 15,726 Ukrainian nationals have arrived by land into Canada, and close to 90,000 have arrived by air. So significant numbers. Since March 2020, about 630,000 applications have been received by the government, with close to 315,000 of those being approved. So IRCC has definitely allocated resources and prioritized applications from Ukrainian nationals. And from my experience, I saw quite a difference in processing times for these types of applications being processed overseas. At the beginning of the crisis, applications were being processed very, very quickly. And as of late, it seems that consular applications overseas are slowing down the processing somewhat. Although inside Canada applications for Ukrainian nationals are continuing to be processed at what seems to be an expedited or prioritized rate. I would note as well that we're not entirely clear, based on what the government has said, how long this current slate of temporary measures will be around. And we are continuing to wait as well for the government to announce more information about a permanent residence pathway for these Ukrainian nationals. So we have lots of clients, and we're eagerly waiting to get more details on that. And I would just recommend everyone who's interested in that area to sign up for our e-alerts and to keep close watch of our website as well. All right, so on that, with that being said, Alannah, maybe we'll look at the questions now.
Yes, I'm just looking. We have a few that might be a bit too specific for purposes of this webinar, but we would encourage you to feel free to send us an email, and we'd be happy to discuss further, set up a consultation, just discuss specific questions.
I'm just trying to see if there are any here. With respect to specific draws under express entry and occupation-specific draws, we would need to review the person's background as well as the specific NOC. To my knowledge, right now there hasn't been any information about specific NOCs that will be included on upcoming in-demand draws under express entry. But I would recommend you contact us so we can do a fulsome review of your background to see your eligibility under either express entry or PNP. That was one question. I think the only other question here that's before we run out of time, there was a question about the students' work authorization and whether that would be potentially eligible for applying for permanent residence. And at this time, my understanding that the government hasn't released any information on whether the work accumulated under the new work authorization program would be eligible to be used under express entry under any of the programs. But that being said, the new programs are relatively new, so I would recommend, again, signing up for our e-alerts to be aware of any new significant updates to Canada's temporary residence or permanent residence programs. But at this time, it does seem like that's we are waiting for further guidance from IRCC. And I think Sorry, Alannah,
I
did you
see a
want to add
question
anything?
here. I just, nothing on that point, but I do see a question here about the difference between the IRCC web forum, the new and versus the old. I don't know that we have a notable difference between the two. I don't know if you have any comments on that, Peter, but I don't think we've seen a substantial difference.
No, not in my experience.
Mm-hmm.
Okay, it seems like we're going to run out of time, so I'm going to stop it right now. But if anyone who did not get their answers, please reach out to Peter, please reach out to Alannah. The details can be found on screen now. I would like to thank everyone for attending today's webinar, and a special thanks to Peter and Alannah for sharing their expert knowledge. And as Peter and Alannah mentioned throughout the webinar, I would encourage everyone to sign up to our alerts and follow us on social media. That's the best way to stay up to date on the latest developments inside Canadian immigration. And until next time, everybody, stay safe and thanks for attending.
Thank you, everyone.
Take care. Thank you.